Good afternoon, everybody. I'm Trudi Seneviratne. I'm registrar for our college. I'm absolutely delighted to be chairing a webinar this afternoon, a really, really important topic, and delighted to have the speakers that we have today. So it's all about coroners and the Preventing Future Deaths reports. And we love this session to be about improving our learning between us all and to think about the impact for our mental health services. So just as an overview and a background, obviously every death that we have to deal with for our mental health patients is a tragedy. It's a tragedy for the families and the loved ones. It's also a tragedy for professionals who are involved in that process, an incredibly sad and also a stressful process. And there are legal processes that have to be followed as part of these processes. And of course, where coroners in an inquest identify issues associated with such death, where they believe that there are actions that could and should be undertaken to reduce the risk of a similar occurrence in the future, they are required to issue a Preventing Future Deaths report, which I'm sure many of us, if not all of us, will have received. So this webinar really will focus on the purpose of these reports, how they impact on psychiatrists and mental health services, and also hopefully look at the opportunities going forward to improve their effectiveness. There'll be an opportunity to hear from the Deputy Chief Coroner for England and Wales, and we're so grateful for you being here, and from psychiatrists, so grateful for our psychiatrists who are here as well, who have a specific interest on this issue and can be part of the discussion of how we might work together and even better in the future. So just a little bit of housekeeping to begin with. You'll note there's a Q&A function with all the speakers. There'll be a Q&A with all the speakers at the end. So please can you post your questions in that Q&A function, and we'll pick all of those up as we go through. There's a tweeting process going on, so if you want to tweet as we go along, it's at RCPsych, hashtag RCPsych Live. This webinar is being recorded, and the recording will be available to watch on the RCPsych website as part of our free webinar page. And there'll of course be certificates of attendance, which will be sent out within a week of the webinar. So what we'll do is that we're going to start with Derek Winter, and we'll move on to Rachel Gibbons, and then we'll have a Q&A at the end. And as always, we finish at 5 o'clock on the dot. So Derek, if I could invite you to onto the stage, onto our virtual stage. I'm so thrilled to have you here, and just a huge thank you to you on behalf of Royal College of Psychiatrists for being with us today. So a little bit about Derek's own background. So he is His Majesty's Senior Coroner for the City of Sunderland, and he's been doing that since 2003. Derek is also the Deputy Chief Coroner of England and Wales, which he has been doing since January 2019. He is the Assistant Secretary of the Coroners Society of England and Wales and is responsible for the membership, website and the annual report. He is a Home Office accredited UK Disaster Victim Identification or DVI Coroner and is part of the Chief Coroner's cadre of DVI Coroners. In October 2014, the Coroner's Office and the Staff Association conferred honorary membership to Mr. Winter. He was a course director for the Judicial College Training for Coroners and Coroner's Office from 2015 to 2019. In June 2015, he became a Deputy Lieutenant for County Durham. So thank you very much, Mr. Winter. Over to you, Derek. Thank you.
Thank you for inviting me. We'll endeavour to put up the first slide, please, Charlie. There we are. That's me. It confirms Trudy's introduction, and what I want to try and do is just refresh your memory about where coroners sit generally. So moving on to the rules of engagement, if I can call them that, the next slide shows the legislation. So we got the Coroners and Justice Act in 2009, and it didn't become law until 2013. So we've now had the new rules and regulations for 10 years. And you can see that the Act is supported by the investigations regulations, the inquest rules support what we could do at inquests. There's the usual financial regulations, and this followed on from the established Human Tissue Act 2004 about what should happen to human material if it is taken following post-mortem examination. So it's taken a while for coroners to get to this destination. And one of the complaints that there used to be was that the only consistency amongst coroners was their inconsistency, because we had 81 coroner areas and there was local reporting criteria, and that led to confusion. Now, the next slide, please, demonstrates that in 2019, we moved on and we had the notification of deaths regulations and the associated guidance around those regulations. And essentially, this was telling all doctors the types of deaths that had to be referred to coroners. So deaths which were unnatural, violent, people who died in state detention, or where a doctor did not genuinely know what the cause of death was. So essentially, doctors were being told, these are the rules. Coroners were being told, these are the rules. There would be no more local reporting criteria. And the regulations supported by the guidance elaborate on what is unnatural. They give some examples of unnatural deaths. That could be people sadly killing themselves. And these regulations have been invaluable, really, to make progress. And then on the next slide, you may not be aware, but there is actually a Royal College of Pathologists cause of death list. And this was revised in June 2020. And essentially, it's an A to Z of most of the causes of death which are acceptable to the registration services. And if they're not acceptable as a cause of death which is natural, and natural deaths don't go to the coroner, then this is a guide for all doctors to know to refer to coroners. And most coroners will take referrals now electronically. Gone are the days where you telephone your referral through to the coroner. You will make an electronic referral through a portal in all likelihood. So in summary, the next slide demonstrates the basic rules of the Coroners and Justice Act 2009. This introduced the coroner's duty to investigate. So if the coroner's duty to investigate is triggered because the death is unnatural, violent, in state detention, or the cause of death is genuinely not known, then the coroner will start an investigation. That investigation may include a post-mortem examination. And if on examination the death turns out to be natural after all, the coroner will discontinue the investigation. However, if the death is unnatural, violent, or in state detention, there will have to be an inquest with or without a jury, and we can discuss that another day. But to give you the idea of the extent of the coroner's caseload, the next slide is a summary of the statistics which are produced by the Ministry of Justice. And I've put the link in there for you for the last statistics. Coroners do an annual return to the Ministry of Justice every May. So the latest statistics are fairly fresh, and you will see that the number of deaths registered in England and Wales was almost 600,000. And 36% of those deaths were referred to coroners because it was believed they were a natural cause of death unknown, in state detention or violent. And you can see that about 90,000 post-mortem examinations took place, and many of those cases would have revealed the death to be a natural cause. So using this sort of funneling effect, there were 36,000 inquests. So you can see from the 200,000 odd referrals, they've been distilled down to 36,000 inquests where the deaths would have been violent, in-state detention, or unnatural. So you've got this constant triaging process in the office of the coroner, who will be looking at deaths coming in, deciding if they're natural, unnatural, whether they need a post-mortem examination. And many of our post-mortem examinations now are by CT scan if they are appropriate for scanning. And of course, we know the outcome of an inquest has to be a conclusion. So let's have a look at the available conclusions on the next slide, please, Charlie. So there we are. The first 12 are what we call short form conclusions. So suicide, unlawful killing, accident, misadventure, you can read them for yourselves there. The 13th in number is called a narrative conclusion, which is usually a brief, neutral statement of the evidence that the coroner has found. It's usually non-judgmental, unless Article 2 is engaged, in which case the coroner can be judgmental and refer to failings. From your point of view, I'll just dwell a little bit on suicide, if I may. Suicide usually means that somebody has killed themselves at their own hand and intended to die at that time. Now, the legal test which applies to suicide now is on the balance of probabilities. That was as a consequence of a Supreme Court case of Morn. And Morn said that all of the conclusions in a coroner's court must be on the balance of probabilities. And that legal test is simply more likely than not. It's not about percentages. It's the weight of the evidence when the coroner applies the legal test to the evidence as the standard of proof. So consequently, suicide moving away from the criminal standard to be sure to the balance of probabilities will mean that more cases will get over that threshold. So you will see in the statistics that I've quoted, I suspect, a rise in the number of suicide findings because some coroners couldn't find both elements on the higher standard of proof, and they would very often record open conclusions. So the statistical data should more accurately reflect what you may encounter in your professional world. And while I remember with the statistics have a dashboard for every one of those 81 coroner areas. So if you practice in a particular part of the country, you can drill down into the number of deaths that were reported in your coroner area, how many went to postmortem, how many suicide conclusions, how many road traffic conclusions there were, and how many prevent future death reports the coroner who you usually deal with has written to organizations or individuals. So conclusions, all very important because they feed into the statistical data, and they're ultimately the snapshot, the end product of what we do at the inquest hearing. And one of the things that I should emphasize in my experience is that most families, when they come to the inquest court, say to me, we don't want this to happen to somebody else. It's very rarely about the compensation or very rarely about condemning the hospital or the doctor or an individual. Many families will say that. And as we know, we put the bereaved at the heart of the process, but not to the exclusion of all others. And nowadays, coroners may have the family read out a tribute to their loved one or what's called a pen portrait. And you can see all of the Chief Coroner guidance on the Chief Coroner's website, which covers a lot of topics about disclosure, post-mortem examinations, and also prevent future death reports, which is the purpose of this discussion. But I'd wanted to put the work of the coroner into some context for you. So if we now turn our attention to action to prevent future deaths, which is on the next slide. So some basic propositions. When the law changed back in 2013, the coroner's discretion to write what was then a Rule 43 report converted to a duty to write a prevent future death report, and that usually occurs at the conclusion of an inquest, because the coroner may have concerns that circumstances creating a risk continue to be in place and action should be taken. Now, very often, and again, I can only speak from my experience, organizations and individuals who may do a serious incident review or what is to become PSERF may well identify in the period from a death to the inquest an issue which has been highlighted either by an internal investigation or the circumstances of the death or matters raised by the family. And it's an opportunity for an organization or an individual to put in a statement to the coroner saying, we've identified XYZ, this is what we've done to deal with that issue which has been arisen, this is what we've done to train on the new procedure and to audit the effectiveness of the new procedure. And very often the coroner will look at that, the family may well be impressed with that, and there will be no need for a prevent future death report because the concern has abated. But in some cases, the inquest will flush out even more concerns, or the actions that have been proposed may be insufficient to satisfy the coroner's judgment. And of course, one of the other features of a prevent future death report is that a local trust may well have remedied a problem, but the coroner may feel that there's national learning. So, for example, the coroner may say, well, this trust have done ABC to deal with this concern, and the coroner might write to the Secretary of State for Health and say, this arose in my inquest, this trust did something about it, and to ensure wider learning, I want you, Secretary of State, to report back to me as to what you've done to spread that learning, because otherwise there will just be pockets of improvement rather than national learning. So it's a really important public health function that coroners perform. As you will know, the coroner writes the report to the organisation or individual who can make a difference. Copies are sent to the other interested persons in the inquest hearing, including the family, and the organisation or person who has received the report from the coroner must respond within 56 days. And the report and the responses are published on the Chief Coroner's website, and I've put the link so you can have a look for yourselves at all of those reports. I would emphasise that when a coroner writes a report, the coroner is not making recommendations, and the press will still dub them as recommendations. I don't have the skills to make specific recommendations to mental health trusts, to psychiatrists, to highway planners, whoever I might be writing to. I can simply raise a concern, and it's up to other people to tell me how they're going to address those concerns. I should also add that a coroner has no follow-up powers. So we can't say we're not happy about the response. We might write a reminder to say we haven't had a response, but if somebody fails to respond, it'll become apparent on the Chief Coroner's website that there's been no reply to that report, and that could bring some embarrassment. So that sets out the law. And I've got some other observations which are on the next slide. So there was a Court of Appeal decision in Moran, and I've quoted this to try and give you some reassurance that an inquest remains an inquisitorial and relatively summary process. So the key words there are, it's an inquisitorial process. It's fact-finding to establish who was the person who died, when they died, where they died, and how they came about their death. Nothing else. nothing else at all. And it should be relatively summary. It should not be overly complex. It should not morph into a surrogate public inquiry. And the Chief Coroner is very clear about getting the inquest heard and listed. It might become complicated because of Article 2 issues or evidence that emerges as part of the inquiry. But the key words are, it's inquisitorial and it's summary. Inquisitorial is different to adversarial. So in the Crown Court, for example, you may have a prosecutor putting a case and a defence lawyer putting the defence case. In the Coroner's Court, there are no cases to be put. There are no parties and there are no finishing speeches, closing speeches. So I always remind everybody it is inquisitorial. Sometimes at the end of an inquest, the lawyers may say, we want to make submissions to me, to the coroner, about whether or not they should write a prevent future death report. The case of Gibbons has made it clear that a coroner need not hear any submissions regarding that matter. If anything, the evidence or a statement may be produced setting out how the trust or an organisation or an individual have dealt with concerns that have become apparent during the inquiry. And then there's no need to make submissions. Prevent future death reports are not a sanction. They're not a means of the coroner censoring anybody. And we really have to move away from that belief that people are on trial. No one is on trial. And I appreciate that people have a sense of coming to the inquest court that there are challenges. And part of what I'm trying to deliver to you is an effort by the Chief Coroner's Office to recalibrate the tone of inquest. And I'll speak a little bit more about that. But prevent future death reports are not about censoring an organisation. And you may get one coroner will write a PFD and another may not write a prevent future death report. And the case of Dillon, which I've mentioned there, is that PFD reports are ancillary to a coronial investigation. So they're a byproduct of the main purpose of the inquest itself. And the High Court, in the case of Dillon, emphasised that the framework that we operate for prevent future death reports is highly subjective. There are some coroners may write a report and others may not. It doesn't mean that one's right and one is wrong. And there was an acknowledgement that coroners are specialist decision makers in this particular area. Now, prevent future death reports on the Chief Coroner's website are searchable, and hopefully in the fullness of time, and if funding was available, and the Chief Coroner, with help from others, may be able to do a thematic analysis of the reports, because currently we can't do that. And that's one of the benefits that we see in the Australian system, where themes that emerge, perhaps in prison deaths, are subject to a further inquiry and further action, hopefully by government. So the next slide just gives you an idea as to what you would see if you tried to do a search. So you go onto the Courts and Tribunals Judiciary website, and you can see when I did this slide that as at the end of July, there were 4,500 reports and replies on the Chief Coroner's website, which shows there's a lot of activity in this particular area. And then if you move into the next slide, if you searched a particular type of report, you will see that, for example, there's a category of mental health related deaths. And you can go into this part of the website and you can see that on the mental health related deaths, there were 441 hits. And you can click on the reports that are shown in this area, and then you can read the report, you can identify the concern, and you can see what the response was. And you'll also gather that coroners use a template report so that this can feed into the Chief Coroner's website. And that template report has meant that the reports are brief and they're targeted and focused, and the concerns the coroners raised are readily identifiable. The responses don't have a template yet, but there is specific Chief Coroner guidance on prevent future death reports if you go onto the Chief Coroner's website, and you can read what the Chief Coroner has said to coroners about reports. So one snippet of information for you, if you wanted to go to the next slide, please. There's an academic at Oxford University who has developed a preventable deaths tracker. And if you go onto this, there's some more information. They have done what I don't understand is something called web scraping, and they've managed to get more data from the Chief Coroner's website onto this, and it also tells you which coroners are writing reports. So I'm mid-range, but I'm way behind two other coroners who are writing lots and lots of reports, and it's up to each coroner how they exercise their duty to write those reports, and that's important to understand. So the next slide, just a quick mention before I give you a little bit of history. Prevent future deaths are not new. They used to be called Rule 43 reports before the law changed, and then the history in a short lesson follows on the next slide. Here in Sunderland, on the 16th of June 1883, we had the Victoria Hall disaster, sadly, when 183 children were killed in a stampede for prizes when the magician presenting the theatre programme started to offer prizes to the children, and all the children in the circle in the upper gallery went down the staircase, and they were aiming to get to the stalls. The door at the bottom of the staircase opened inwards, and the children, there was mass suffocations essentially and crush injuries. Now, interestingly, although the tragedy happened on the 16th of June, the coroner here in Sunderland did the inquest on the 9th of July 1883, 23 days after this calamity. That was a phenomenal pace. There was a jury called, and they used a questionnaire devised by the coroner to elicit their verdict, as it was then known, on the issue of neglect of duty of the staff in the theatre and the safety regime in the theatre. And the point to demonstrate is that there were safety recommendations came out of this disaster even in 1883, and a local architect, Robert Alexander Briggs, designed what we are all familiar with, and I'll show you it on the next slide. This is the push bar safety door as a fire escape, and this was designed by an architect in Sunderland, a trainee architect indeed, and that demonstrated that some good came out of such an awful tragedy, even as long ago as 1883. So my message is that prevent future deaths are a force for good. They're a good public health function of the coronial jurisdiction. And I did see either a comment or a question appear on the screen when I was talking about inquisitorial jurisdiction, and somebody said it doesn't feel like that. And I'm sorry if that's their experience, because the next slide is something that I wanted to specifically draw your attention to. The Chief Coroner's Office have been working hard with the regulators for the lawyers. So the Bar Standards Board, the Solicitors Regulation Authority, the Institute of Legal Executives. And we have created some competencies for lawyers about communicating effectively, working with other organisations, keeping knowledge up to date, resources and training providers. And we've also created a toolkit for all of those lawyers, so that we can hopefully recalibrate the tone of inquests, as I've said, because they should not descend into the adversarial. There's nothing wrong with asking a witness a difficult, even robust question, but the manner in which the questions are put is key. And it really is important that the witness gives their best evidence and that the coroner takes control of the manner of those questions. And if the lawyer does not comply, the coroner can report them to their regulators. So we've done a lot of work to take away, if we can, the adversarial nature of some inquests, not all, but just be aware that there are tools for the lawyers out there, and a good inquest lawyer will know what to do, and it's really important that you are aware of that. So just moving on swiftly to some other resources which I've listed out for you. The Office of the Chief Coroner, there's a website. The Ministry of Justice have a guide for coroner services. It's directed towards bereaved people, but you should know what they're being told, what can happen and not happen. The Coroner Society have a good website. There is something called the Advocates Gateway, which is designed really for all lawyers to be able to communicate effectively with witnesses, particularly vulnerable witnesses. It should not be for the witness to adapt to the lawyer's style. It should be for the lawyer to adapt to the vulnerability of the witness. And also, it's a publicly accessible document, the Advocates Gateway. Same for the Equal Treatment Bench Book. This is a vast document advising all judges, including coroners, how to deal with all manner of treatment issues that may surface. And then just finishing off on references to the next slide, please. There are some useful contacts you can have, and just moving through to the next reference section. So next slide, if we could, Charlie. There's a huge number of useful information out there. Some decent books, some are more expensive than others, as you would expect. A lot of learning came out of the Hillsborough inquest and inquiries, especially about the careful use of language. So we don't say a body is the property of the coroner. We don't say, or should not say, that somebody has committed suicide. People die by suicide, and language is really, really important in the coroner's court. And then the final reference slide. I've done a podcast with the Faculty of Intensive Care Medicine, and it's all about going to court and death certification. You may get some tips from that if you wanted to listen to it. And there I've mentioned the competencies and the toolkit. So I'm conscious that people do feel undersaged sometimes when they come in, and you know, the experience should be for you to give your account, and I would like to think that everybody gets a positive experience, because you do good work. And sometimes families need that explanation in court or in advance of court. And there's a lot of good work goes on behind the scenes where families are given that care and attention. And it's usually when they haven't had that experience of good care and attention that there are misunderstandings. And, you know, coroners don't deal with complaints. We deal with what we've got to do under the Coroners and Justice Act. So thank you very much for listening. That's all for me. I've tried to shoehorn as much information in as I can, and I'll stand aside for the next speaker.
Derek, that was absolutely fantastic. Thank you. That was such an excellent and informative session. I wrote down so much material here. I can see there are lots of questions already. So if we leave those questions in the chat, we can come back to them after Rachel speaks. Thank you, Derek. So let's move on then to Rachel. So Dr. Rachel Gibbons has worked in the NHS over the past 20 years in various psychiatric settings as a consultant psychiatrist and consultant medical psychotherapist. She has recently been working as the National Director of Therapies for the Priory Group. She is a psychoanalyst and group analyst and current co-chair of the Patient Safety Group. chair of the working group on the effect of suicide and homicide on psychiatrists, and vice chair of the psychotherapy faculty at the Royal College of Psychiatrists. She's been working on suicide over the last 14 years. She was the suicide lead for Barnet and Enfield and Haringey Mental Health Trust, a founding member of the Haringey Suicide Prevention Group, and clinical lead for the London Transport Police Suicide Prevention Team. She is one of the co-authors of 2 RCPsych reports called Self-Harm and Suicide, released in 2020, and the guidance for all mental health organisations following the suicide of a patient, which came out in January this year. She's been facilitating peer support suicide group for consultant psychiatrists over the last 14 years. And she's also recently published papers on the effect of suicide on the clinician. So Rachel, a huge amount of experience. Thank you for being with us today. So over to you. Thank you.
Thank you, Trudi. I'll just share my screen, if that's okay. And just check that everybody can see my slides. Okay.
Yes, we can. Thank you.
Fantastic. So my sort of role today is not to speak for too long. I'm going to just talk a bit about the role of the mental health clinician in the Coroner's Court, but I'm also going to touch on the nature of suicide and the impact of suicide on the mind of the bereaved, and how that actually impacts on the experience in the Coroner's Court, or what the thinking is about this impacting on the experience in the Coroner's Court. But before that, I really want to say thank you so much to the Deputy Chief Coroner, Derek Winter. I can't tell you, I was actually feeling quite moved hearing you talk. I think by the amount of clinicians that are here on the webinar, I think we've got 1,000 signed up. This is a really important area for clinicians. And I think a lot of that is because we actually share, we come together, we join with coroners in this very human and painful task at many points in our career. As a clinician, we can expect to come to the Coroner's Court probably 4 times, and depending on our job, if we work in a crisis team, for example, probably more than that. And I was just thinking myself, I probably was about 10 times in my career. So I was just going to mention just something about my own experience, in that I had 3 deaths by suicide in the first 3 months of being a consultant. So I went to the Coroner's Court 3 times in my first year, and I can truly say it was the most frightening experience of my life. And that wasn't anything to do with the coroner at all, who was actually masterful, but it was to do with the sort of the state of my own mind. I mean, I was very traumatized. In retrospect, I know that I had a post-traumatic stress disorder. I didn't really know that at the time, but in the aftermath of suicide, feeling of 3 deaths in particular, but it actually was the same with 1, actually feeling that it was my fault, that it was my responsibility, and that somehow, in a way, as Derek has already said, this sort of sense that I was being tried in the Coroner's Court, that I was going to be found guilty and responsible for the death, and trying to face that, that fantasy before coming up against the reality is actually really quite frightening. But actually, the coroner was, as I was saying, absolutely masterful, and really helped me and the family, and contained the situation extremely well. So as a result of that, those experiences, I spent a lot of time working on suicide with other people now, and with other clinicians, and we've done research into the impact of the Coroner's Court and suicide on clinicians. And this is just a few excerpts from that. What we found is that well over sort of 70% of, or 80% of clinicians following death by suicide of a patient were significantly affected, both emotionally in their personal and their clinical life, but also in their clinical work. They found it difficult to work clinically afterwards. So these are just some quotes from the clinicians there. Initially shock, things deteriorated after a month, tearfulness, unable to focus, intrusive thoughts and memories, nightmares, resentment, shame, helplessness, finally post-traumatic stress disorder, like being deeply wounded. So shame, guilt, it kept me awake at night. It affected subsequent career choices. It affected my capacity to work. It feels it's something I'll have to carry forever. I think of the boy often. And yet what it boils down to is I don't blame myself. It's the line of work, isn't it? One thought I had at the time, and still have, is that if I had another suicide, I'd resign and do something else with my life. And what we actually found is that a lot of clinicians did change path, some retiring and leaving mental health altogether as a result. Of course, not all people were impacted very differently. But what we also found in the research was the impact of the suicide was affected a lot by the processes that followed. So this included the serious incident inquiry and the coroner's court. So that if these experiences were supportive and thoughtful, they could be reparative and helpful, but sometimes they weren't, and sometimes they were quite traumatic or even persecutory. So this is sort of represented here. This suicide was upsetting. However, the aftermath, the serious incident investigation and attending the coroner's court was very traumatic for me. It made me feel very upset, sad, like people were out to blame us, me, services. The sense of shame and responsibility that seems to be accepted in the whole psychiatric community about suicide didn't help. Harrowing, terrifying, sobering, felt like I was going on trial, but the coroner was clear and made it easier. So, and what the feedback we also had from clinicians, which is, I think, very touched on in Derek's presentation as well, was it felt that there were two different tasks, the sort of primary conscious task of the how, where, when, who, but then there was another very important and powerful emotional task to do with helping and supporting the grieving process, not only of the family and friends, of course, but also of the clinicians, because we're bereaved as well, and other stakeholders there. So that it could be a very powerful emotional experience where you're caught in the maelstrom of the most intense grief. So I want to talk a little bit, just touch on something to do with the nature of suicide. So, you know, we've done a lot of work in this area, looked at a lot of data and gone through a lot of research. And what it seems, and I'd be very interested to hear what Derek thought about this, but it's actually very difficult to predict individual suicide. It's something called the low risk paradox. So Manchester produced the National Confidential Inquiry each year, looking at deaths by suicide and homicide. And they find that 73% of those that die by suicide have not been in contact with mental health services in the previous year. So haven't been sort of noticed in that way. And of the 27% that have, and have had a risk assessment at their most recent contact, 80 to 90% have been rated as low or no risk. So what this does, and certainly the data we've looked at as well, is that it seems, if not very difficult, if not impossible, to predict who is going to go on and die by suicide. So that's sort of very important to keep in mind. And as a result, of this, suicide comes out of the blue for many, many people. Also, we don't understand the nature of suicide itself yet. We don't understand the mental mechanisms that lead to suicide. So that makes it very difficult to understand. I think one of the current theories is very much related to mourning and loss. Certainly psychoanalysts are of the opinion that suicide is a result of a difficulty or inability to mourn a significant loss event, and that suicidality is a normal part of the mourning process, and that suicide can result from an incapacity to mourn. But other than that, actually our understanding of suicide is very limited. And also in any individual case, the etiology can't be determined. The person that could talk to it isn't there anymore. About 20% of people, I think, again, Derek might be able to comment on this, leave suicide notes. And when examined, they really don't give good reasons, very, very rarely give good reasons for the death. So the etiology of any death can only be theorized. It can't be reality tested at all. So the result of this is that if you have a death, a terrific, very sudden loss event come out of the blue, that you'll never know why it happened. You're left in a state of utter unbearable uncertainty, loss, grief, that your mind can't really cope with that. So what happens, you can't sit in that sort of uncertainty and grief. Your mind fragments. And what you do as a means of coping with that, is a very human response, is to create a narrative. We're narrative animals. So we create a narrative, and the narrative takes the same a form for everybody. Really, it seems to take a very similar form, which is the bereaved is the protagonist, and they have made a fatal mistake that's led to the death. And however painful this narrative is, in some ways it's better than this fragmentation. So there's a very strong drive in the aftermath of suicide for these narratives of blame. So we know what happened, we know who's responsible, it's them, and sometimes if it's me, then I really need to blame someone else often for my own survival. So these very powerful, very hard to resist narratives of blame. And this is a very moving quote from a bereaved father about this. He said, "It was several months before I'd have been able to think through my son's death, and then a further years before I could place this in a perspective that allowed for the unknowability, the limits to intervention, and allowed agency of some kind to my son in his own death. There was a time when finding others responsible was important in preserving the integrity of my son, finding causes in myself and others who didn't keep him safe. It might help professionals to place the anger or blame they may experience from families in the context of the grief the families are going through. The point is the family's engagement with professionals in the early period may be shaped by their need for a narrative of the suicide with which they can live, driven by their need for emotional survival. Narratives of blame serve to protect a family's relationship with the one they've loved and lost." So just before I finish, I just wanted to end really on the a personal testimony. And just to say, I think it's this energy of these narratives of blame and the feedback we get from clinicians about coroners' courts. We get so much. I chair this working group on the effect of suicide and homicide on clinicians, and we get so much energy and thoughts about the coroners' court. And some feedback is that it was incredibly helpful and reparative, and others that it was very difficult and challenging and persecutory. And sometimes people came away feeling that they had been blamed or got to carry this narrative of blame for other people. And sometimes I think the clinicians can be supported by their organisations, but they can also be abandoned by their organisations if the organisation itself is trying to protect itself. So they can be in a very isolated position, carrying not only their own grief, but also it can become a sort of object or a receptacle for the narrative of the death, and may feel unsupported by their organisation, or even sort of abandoned or even scapegoated by their organisation. So it can be very difficult indeed. So this is the quote from a colleague. "The suicides of my patients haunted me. I was enduringly traumatised by some and became avoidant. It's like the security services in the Westminster Bridge, waiting for it all the time, and then it happens. The first few days afterwards are awful and panic-stricken. Having to talk to the family at this stage is one of the most difficult things to ever have to do. There are different stages to my response. At the beginning, shock and numbing. Then there's a serious incident inquiry and the inquest. It's very difficult to bring yourself to do the coroner's report, to revisit everything, to be afraid of what you'll discover. Everything reads differently compared to when you wrote it. Sometimes the inquest can feel fair and give some resolution, and sometimes it's terrifying. To stand in the witness box and be cross-examined by family, sometimes for hours, always maintaining a professional stance, editing one's own emotional responses, it's really hard. Not being allowed to say anything publicly of how you might be feeling." And I suppose when it comes to the prevention of future deaths reports, and thinking of what Derek was just saying about these serious incident reports can often be very important in the coroner's inquest. I think we have concerns about the serious incident reports, that there's a pressure of producing something in a very short space of time, and organisations might try very hard to protect themselves. So it might not be hugely absolutely accurate or truthful of what the situation was before the death. So I think that's sort of important to have a think about, and what it is that could really help in prevention of future deaths. And we hope very much, we're so pleased to be able to link up, and we hope this is a start of a collaborative relationship. How can we link and help each other in service of the prevention of future deaths, that help in really true learning, so that the sort of narratives of blame don't get into the sort of dynamic and push forward something that might not be wholly representative of what the difficulties may be, or the systemic difficulties there might be. So help in true learning and care and compassion following these painful and tragic deaths. And I'll stop there.
Rachel, that was absolutely fantastic and a really, really powerful talk there. Hopefully you're both back on the screen now, aren't you? Back on the platform. Gosh, we've only got 9 minutes. I feel like we need so much more time to go through some of some really important, complex questions actually, and think about the future. But we have only got 9 minutes, so let me just fire some questions that have appeared.
Can I volunteer an answer to one that I saw, Trudy?
Oh yeah, please do, Derek. Yeah.
Somebody asked whether everything is always published. We have a redactions policy in the Chief Coroner's office, because one of the things that we don't want to do is to publicize methodology around suicide, because there's a risk of copycat. So we will redact those details. And sometimes some families, particularly where it's a child suicide, we may redact a name as well. Although the inquest hearing is in public and the media can come and attend and report, the Chief Coroner's Office will look at prospective redactions. So we do take that side of things seriously, and we will remind journalists, for example, about the Samaritan's guidance as well about reporting. So coroners will get training on all of these things. We have 2 days compulsory training every year, residential, for coroners and coroners' officers. And it's just a couple of years back we did mental health as a module, let's say, over 2 years. Over 2 days, sorry.
That's really helpful, thank you. There's one that's popped up about process, just about the length of time people have to wait for availability of dates and things, and sometimes extending to 9 months, and how distressing that can be for families and everyone involved. I guess, I don't know whether you wanted to comment on that one.
It is. The rules provide that we should normally do inquests within 6 months. That's what the target is. If we take any longer than 12 months, we have to report ourselves to the Chief Coroner, who will publish everybody's delay statistics. Sadly, there's a lot of issues at play in terms of witness availability. Some mental health deaths, because it's state detention, require a jury. We are still catching up after COVID as well, because we couldn't have jury inquests because of social distancing rules. So we're trying to attack all of that with newly appointed assistant coroners and area coroners, and prevailing upon local authorities to improve our resources. But yes, the delay can be the enemy of justice, I'm afraid. And it's not just families, but I feel for professionals who need to sort of tell us their story as well, and the worry about delay. So yes, I agree. We should do better.
Yeah, thank you. And what's generally classed as misadventure?
I would put that down as usually the unintended consequences of your own actions. So if you try and chase the waves on the seashore, you could call it an accident, you could call it a misadventure. For statistical purposes, for those of you who want to look at the MOJ stats, accident and misadventure are deemed to be the same.
I'm sure people will be looking at that. And why is it treated differently to something like death by cardiac arrest? Why is suicide treated differently?
Suicide is, I mean, the GRO have all sorts of statistics for suicide. So for coroners' suicide data, even if you said Joe Bloggs killed themselves intentionally, but their intention couldn't be ascertained, I suspect GRO would put that down as a suicide. But it's classification of data. But the way coroners are set up, we have 12 short form conclusions by law and a narrative. So we have to put them into some category at some stage.
That's wonderful, thank you. You can see that lots of questions coming in your direction, Derek. Rachel, you were asking about just that relationship and how people can feel less frightened in that process. Is there anything you wanted to ask of Derek?
Well, that's what I was wondering a bit. I was wondering a bit about that. actually, whether you had any thoughts about that, Derek. And
yeah, I do. I think engagement with your coroner locally is really important. You know, dispel the myth of what the coroner can and can't do. If you're going to be going to coroner's court, write a good statement. If it's not controversial, you may not be called to give evidence. The statement can be admitted in writing without you being called. Go and have a look at the coroner's court before you attend. The coroner's court will have coroner's court support service volunteers to support everybody attending court, whether it's the family or a professional witness. Some of us now in the coroner's world, we have bereavement nurses. So they've popped up in Rochdale, Liverpool, and we're about to get a team of bereavement nurses, and they will support people involved with bereavement, whether families or professionals, including the coroner or coroner's officers. So there's a lot of things people can do to, as I say, to demystify the process, or get your coroner to go along and give a talk to the mental health teams, and to explain what neglect in the coroner's court means, because it's a term of art. Mm-hmm. And some families and lawyers bandy neglect about without actually understanding what it means. It means a gross failure to provide something of a basic nature to somebody who's got an obvious need for it and who's in a dependent position. So coroners can explain all of these concepts and what state detention means, and what things we want to look at. Engage.
And if we've got a clinician coming to the coroner's court, what do you want out of them giving evidence?
Personally, I want their best evidence. I want a decent statement, which I will have disclosed to the family. I want a chronology of events, no speculation or opinion. And just to, you quoted, Rachel, the experience of somebody in your presentation. I never use the word cross-examine in my court. Mm-hmm. You know, we don't follow the rules of the adversarial courts. Mm-hmm. So I have examination, the coroner goes first, then the family have the right to put questions which are relevant to the fact-finding nature of the coroner's inquiry, and then usually the trust will tidy up at the end by way of clarification, and I will only allow relevant questions to be put, not every question. And I always make, for example, the family commit their concerns in writing, because it's very easy to say they're worried about something without actually being specific. And then the team can answer the family specific questions. And sometimes with a good inquiry, you call fewer witnesses, and sometimes the family turn around and say, we understand now, we're not going to come, we'll do the inquest in writing. Mm-hmm. So there are techniques you can deploy as a coroner and as witnesses to aid the process.
Thank you so much.
That's wonderful. And I think what you said about coroners being a public health function, I think is so important. So listen, we've got less than a minute left, and I'm aware of so many questions. Could I ask you both to have a look at those questions and answer before we finish, and we can post those back on our website? But perhaps just to finish and say, Derek, thank you enormously for coming along and working with us. I love the podcast idea. This video will be available, but perhaps there's an opportunity for a future podcast with the Royal College of Psychiatrists. And Rachel, thank you enormously yourself as well. Perhaps it's the two of you together. And I think there's also some data that can be looked at that you've mentioned today. And we have a huge department that is looking at prevention, and that might be an opportunity for future research as well into this area. So thank you both so much, and just thank you to the audience who've come along to listen today. And hopefully there'll be further opportunities to look at this in the future.
Thank you.
Thank you, everyone.
Yes.
Take care.
Happy to help.
Bye.